Today we will discuss the topic e-governance. The e-governance is the application of information technology in the functioning of governmental activities and thereby allowing direct participation of the citizens in the policy making, policy implementation and decision making. It brings about transparency in governmental services and makes the system not only responsive but also more accountable towards the citizen. It will bring less bureaucracy, more transparency and openness. E-service delivery or delivery of the governmental services through the electronic medium promises to change the face of government-citizen interaction. In fact, it would be more appropriate to say that this process holds out the promise of revolutionizing the manner in which the governance as a whole will be carried out in the near future. E-governance is the application of information technology to processes of government functioning in order to bring about simple, moral, accountable and responsive and transparent governance. The credit of developing this concept without any idea of doubt goes to the internet. In this World Wide Web information system, which has made it possible to put into practice the idea of taking the government, or should we put it governance, right to the doorsteps of the citizens. First, we will discuss what is e-governance, what does it mean. E-governance is the application of information communication technology to the process of the government functioning so as to have simple, accountable, speedy, transparent and responsive governance. Further, the World Bank defines e-governance as the use of information and communication technologies by government agencies to transform relation with citizens, business and other arm of the government. It involves information technology enabled initiatives that are used for improving the interaction between government and citizen or government and business, commonly known as e-services. The internal government operation, commonly known as e-administration. External interactions among the member of society, commonly known as e-society. According to another definition, e-governance is a form of e-business which involves delivery of electronic services to the public like citizens. It also involves collaborating with business partners of the government by conducting electronic transactions with them. It enables general public to interact with the government through electronic means for getting the desired services. In other words, e-governance means application of electronic means in the interaction between government and citizen, citizen and government, government and business, business and government, internal government operation. The main objective of e-governance are to simplify and improve governance and enable people's participation in governance through mail and internet. E-governance is not only proving information about the various activities of the government to its citizens and other organizations, but it involves citizens to communicate with the government and participate in government decision making. Further, he opined that e-governance is applied in the following ways. One is putting government laws and legislation online. Then putting information relating to government plan, budgets, expenditure and performances online. Then putting online key decisions like environmental decisions, citizens' right to decision, etc., which are important to citizens and create precedents for the future action. Making available contact addresses of local, regional, national, international official online. Making available the reports of inquiry committee, commissions online to the affected parties. Making available information about human right violation by government or its officials online to the concerned citizen and NGOs. Then to evaluate the effectiveness of current policies and identify their strengths and weakness and measures to overcome those weaknesses. Another one is to enable informed decision making at all levels by enhancing the background knowledge and providing a rationale for future course of action. Another one is to evaluate the performance of decision making bodies, to establish an interactive communication channel with key policy makers and members of planning commission. Then to conduct public debates, opinion polls on the issues of wider concern before formulation of policies and legislative framework. Filing of grievances and receiving feedback from the citizen as well. Then establishing decentralized form of governance. Digital democracy, a way to real democracy. This is the application of information technology in the Indian system will make the dream of a good Indian democracy a reality. It will open all the doors of the information to the public at large, which will further lead to the people's empowerment. The hallmark of good administration or good governance is the extent to which common man is able to enjoy the government services. It is the ease and convenience of a common man's access to the government services that actually determines the level to which an administrative system can be said to develop the level of administration by making it easier and convenient for the citizen to approach and make use of the government services. And it is also a part of the development administration in as much as taking governance close to the citizens in the highest form of development service that an efficient administration can hope to implement. Then we will discuss what are the advantages of e-governance. E-governance is not merely a computerizing existing governments. It is transforming the existing government in the new network society. Governments must re-engineer themselves and shift from passive information giving mechanism to have active citizen involvement system and must facilitate much faster, cheaper, convenient, transparent and dynamic interaction between government and citizen. Sometimes it is also called as integrated governance as it integrates people, processes, information and technology in the service of achieving the governance objectives. E-governance has the following advantages. The very first one is cheaper governance because it cuts financial and time cost. Then we can say quicker governance by producing the same output at the same total cost in less time. Then you can say close monitoring of government processes or performances, more accountability of public servants for their decision and action. Then you can say improve government efficiency and productivity, which facilitates the delivery of government services to citizens through procedural simplicity, speed and convenience, and above all improve public image of the government by making governance transparent. E-governance and law in India, the Information Technology Act 2000 and e-governance, it's important to note that Chapter 3 of the Information Technology Act 2000, Section 4 to 10A deals with this concept of e-governance. However, important provisions are legal recognition of electronic record, which is defined in Section 4 of the IT Act, where any law provides that information or any other matter shall be in writing or in the typewritten or printed forms, then irrespective of anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in electronic form, accessible so as to be useful for subsequent reference. According to Section 4 of the law requires that any information or matter must be in writing or in handwritten form, then such requirements shall be deemed to be satisfied if such information is in electronic form. Therefore, Section 4 confers validity of electronic record. Then we will discuss Section 5, which defines legal recognition to digital signature, where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document shall be signed or bear the signature of any person, then irrespective of anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is authenticated by means of digital signature affixed in such a manner as may be prescribed by the central government. Section 5 confers validity on digital signature. It provides that whenever law requires that any information or the matter must be authenticated by affixing the signature or document must be signed by a person, then such requirements shall be deemed to be fulfilled if such information, matter or document is digitally signed. Use of electronic record and digital signature in government and its agency is defined under Section 6 subclause 1, where any law provides for the filing of any form, application or any other document with any office, authority, body or agency owned or controlled by the appropriate government in a particular manner, or the issue or grant of any license, permit, sanction or approval by whatever name called in a particular manner, or the receipt of a payment of money in a particular manner, then irrespective of anything contained in any other law for the time being in force, such requirements shall be deemed to have been satisfied if such filing, issue, grant, receipt or payment, as the case may be, is effected by means of such electronic form as may be prescribed by the appropriate government. Then we will discuss the rules by the appropriate government, which is defined under Section 6 subclause 2. For the purpose of Section 6 subclause 1, the appropriate government may by rules prescribe the manner and format in which such electronic record shall be filed, created or issued. Then the manner or method of payment of any fee or charges for filing, creation or issue any electronic record under clause A. regarding the use of electronic record or digital signature in the government offices or agencies, rules are to be made or framed by the appropriate government. Then we will discuss authorization by the appropriate government to set up, maintain and upgrade the computerized facility, which is defined in section 6A subclause 1 for the purpose of e-governance and for the efficient delivery of services to the public through electronic means. The appropriate government may, by notification in the official gazette authorized by order, any service provider to set up, maintain and upgrade the computerized facilities and perform such other services as it may specify. According to this section, the appropriate government may order any service provider to set up, maintain and upgrade the computerized facilities and to provide such services in electronic form. Service provided section 6A. So, it is important to note that service provider so authorized includes any individual, private agency, private company, partnership firm, sole proprietor firm or any such other body or agency which has been granted permission by the appropriate government to offer services through electronic means in accordance with the policy governing such service sector, collection etc. of the service charges, which is defined in section 6A subclause 2 and subclause 3. The appropriate government may also authorize any service provider authorized to collect, retain and appropriate such service charges as may be prescribed by the appropriate government for the purpose of providing such services from the person availing such service. Further, the appropriate government may authorize the service provider to collect, retain and appropriate service charges under this section, even if there is no express provision under the Act, rule, regulation or notification under which the service is provided to collect, retain and appropriate e-services charges by the service providers. Government to specify scale of service charges defined under section 6A subclause 4. The appropriate government shall, however, by notification in the official gazette specify the scale of service charges which may be charged or collected by the service providers under this section. Further that, the appropriate government may specify different scale of service charges for different type of services. It is significant to mention here that apart from directing a service provider to provide the services in electronic form, the appropriate government may direct such service provider to collect, retain and appropriate service charges in the electronic form, even if there is no express provision under any other statute under which service is provided to collect, retain and appropriated charges for the service so provided. Then we will discuss retention of electronic record, which is defined in section 7 of the IT Act. Where any law provides that documents, records or information shall be retained for any specific period, then the requirement shall be deemed to have been satisfied if such documents, records or information are retained in the electronic form. However, following conditions must be fulfilled for that. The very first one is the information contained therein must remain accessible so as to be usable for the subsequent reference. The second one is the electronic record must be retained in the format in which it was originally generated, sent or received, or in a format which can be demonstrated to represent accurately the information originally generated, sent or received. Another one is the detail which will facilitate the identification of the origin, destination, date and time of dispatch or receipt of such electronic record must be available in the electronic record. However, this clause will not apply to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. There are some exceptions under section 7 subclause 2. This section shall not apply to any law that expressly provides for the retention of documents, records or information in the form of electronic record. Then we will discuss the provisions for the audit of document to be applied in document, which is defined under section 7 subsection A, which is inserted by the Information Technology Amendment Act 2008. Wherein any law for the time being in force, there is a provision for the audit of documents, records or other information, then the provision shall also be applicable for audit of documents, records or information processed and maintained in the electronic form. Therefore, audit of the document means audit of the e-document also. Publication of rules, regulation, etc. in electronic gazette defined in section 8. Where any law provides that any rule, regulation, order, bylaw, notification or any other matter shall be published in the official gazette, then such requirement shall be deemed to have been satisfied if such rule, regulation, order, bylaw, notification or any other manner is published in the official gazette or electronic gazette. This section confers validity on e-gazette. Therefore, today, apart from publishing rules, regulations and bylaws in the official gazette, the appropriate government also publish them in e-gazette. Then we will discuss no right to insist government office etc. to interact in electronic form, which is defined in section 9 of the IT Act. Nothing contained in section 6, 7 and 8 shall confer a right upon any person to insist that any ministry of department of the central government or the state government or any authority or body established by or under any other law or controlled or funded by the central or state government should accept, issue, create, retain and preserve any document in the form of electronic records or effect any monetary transaction in the electronic form. It is significant to note that section 9 is the biggest loophole of the Information Technology Act 2000. On one hand, the main aim and objective of the Information Technology Act 2000 was to facilitate e-governance. However, on the other hand, section 9 provides that no one can insist any government office to interact in electronic form. Then there is a power to make rules by the central government in respect of digital signature, which is defined in section 10 of the IT Act. The central government may, for the purposes of this act, by rules prescribe the type of digital signature, then the manner and format in which digital signature shall be fixed, then the manner or procedure which facilitates identification of the person affixing the digital signature, then the control processes and procedures to ensure adequate integrity, security and confidentiality of electronic records or payments, and any other matter which is necessary to give legal effect to the digital signature. Then we will discuss validity of contract forms through e-form, which is defined in section 10A. Where in a contract formation, the communication of proposals, the acceptance of proposals, the revocation of proposals and acceptances, as the case may be, are expressed in electronic form or by means of electronic record, then such contract shall not be deemed to be unenforceable solely on the ground that electronic form or means were used for that purpose. It is important to note that section 10A confers validity on e-contract. Therefore, where the proposals, the acceptance of proposals and revocation of proposals or acceptances are made in e-form, then such contract shall be valid under Indian Contract Act 1872 and shall not be unenforceable solely on the ground that such electronic form or means was used for that purpose. Then we will discuss e-service delivery. To begin with, the most important aspect of e-service delivery which deserve consideration is the extent of such system. There is how many services can be provided to the citizen through the electronic medium. The answer this query is straight, simple and better. Although the development of internet has shown infinite number of possible ways of taking the services, information to the citizen, it requires a lot more planning when it comes to delicate issue of governing through the electronic medium. Though the government of India has already started providing services in the income tax department, custom and excise government procurements, transport, etc., but it is just start. Effective implementation is still to be achieved. However, tempting it might be, the idea of effective e-governance can be realized only after some of the basic but complex issues are resolved. Issues in implementations. Then we will discuss what are the issues in implementation of e-service delivery can be broadly be dealt at two levels. The one is issue relating to technology infrastructure development. Another one is issues at operational level before we move on the delivery of e-service. The foremost requirement is the development of infrastructure. The government need to invest a lot of capital in the IT industry. Database will have to be developed and also other programs to periodically update the information so that citizens get the current information. The most important requirement is to develop local language, software so that wide reach of e-service delivery is possible. However, another important issue that cannot be ignored deals with the security measures that need to be adopted for a safe system. The problem that needs to be sorted out in regard to the e-service is the problem of detailed, in fact, cumbersome application procedure which is required to be filled for practically even public services. By merely providing for online filing of the application form, that will not serve any purpose. It has to be kept in mind that e-governance does not mean that entire bureaucratic red tape which harasses the citizen in the government offices to no end should now be transported onto the electronic medium as well. The online application form for the respective services should be made as concise as possible. Another very important issue is that of transparency. E-governance should assure in era of public right to information of official record, save in the cases of document records which relates to the security of the state. Of course, this right has been limited in nature. Yes, it is necessary to have such a right because its arbitrary use of discretionary power, some measures of which is vested in every public official, which to my mind is the most important reason for the rampant corruption in India's public life. The dealing of officials must put in on the website the reason for the delay or the grant or refusal of each application. In concluding remarks, I must say a successful model of e-governance would require a combined effort from various sectors. For example, building an efficient infrastructure for e-governance, it is important to have a good communication network. In this context, the importance of telecommunication and the concept of convergence can hardly be overstressed. Similarly, for filing the tax returns, bills, etc., it is important to electrically interconnect the public sector bank and other government financial institutions for better e-governance. This government effort will have to be supported by the private sector by providing hardware as well as software and thereby fulfilling the technological needs of the system. E-governance will further redefine the public government interface by enabling improved connectivity and communication between all stakeholders. E-governance truly has the potential to propel the country on the path of overall advancement. E-governance at the state and village level will truly make India a true and real democracy that will take services of the government to the doorsteps of the common man. Thank you viewers for listening this program.